Okay. I can do it two ways. I've got a little slideshow and I can do a talk, or if people just want to ask me questions, I'm more than happy to do that, either one. Does anybody have a preference?
Let's start with slideshows.
Okay, slideshow it is. This is one that I have kind of done to, it's really simple. It's a part of one that I do to paralegals. Can anybody see it?
Yes.
Okay, good. Let me take care of this. And we'll start with the basics. Does everyone understand what wills, trusts, and probate are? Okay, a will is a document that you create that has certain formalities to it that informs the court of what you want to be done with everything you own when you pass away. It does not by itself transfer any rights to anybody or title or anything else. It has to go through probate before it's active. And when we say a will has been probated, that means that we have submitted it to the court and it has gone, actually, usually it's an administrative assistant that looks at it, not the judge. And the court has approved it, has said it's a valid will. And then usually the executor is just sort of allowed to go off and do what they want to. The other type of probate is intestate, which means you don't have a will, which has a lot more to it a lot of times. You can request the same independent executorship in probate that you do if you have a will. You can request it in an intestate situation as well as when you have a will, but it won't necessarily be granted by the court if there's no will saying that it's independent. And if it isn't independent, then that means the court supervises every little thing that you do. You have to go to court to get permission to do something, then you have to go do it, then you have to go back to the court, show them what you did, and have them approve what you did. So a will is very important that way. There's also the fact that if a person has been married before and there's no will, community property is split between the spouse who takes what they already own, which is their community half. The other community half, which belonged to the deceased spouse, is given to the kids. So, and if anything's separate property, it almost 100%, I mean, 2/3 of it goes to the kids for the most part. That's a kind of a globalization, but because you have different items that different percentages go to, but the kids get the bulk of it. So a will is very important if you want your own desires to be expressed after you're passed away and to be carried through to take care of your family. And that's pretty much what a will is. The one way that you can go and do well, it isn't probate, but the one way that you can use a will without going through probate is you can do either a muniment of title or an affidavit of heirship. A muniment of title is just an abbreviated probate where no executor is appointed. There's just an order issued from the court that says these are the heirs. And then you take that to some places will honor that. You take it to them and they give you whatever they have. They just divide it up and give it to all the people that are named in the order. There's the other way is an affidavit of heirship. If you're going to sell the property, an affidavit of heirship is, let me see how to explain this. There's a law in Texas that says that if you reduce a witness's testimony to writing and file it with the county clerk, and you aren't doing probate, then you can go back within then after 5 years on file with the clerk. That affidavit is as good as if the person came in and testified. So because of that, a lot of mortgage companies will honor these affidavits even if you've just done them and placed them on file with the county clerk. Legally, they're supposed to be on file for 5 years, but if you place them with the county clerk, then most mortgage companies will honor them. Banks, however, won't a good percentage of the time. So affidavits of heirship are good if you're going to sell the property, but if you're thinking about refinancing it and want to get it into your name, usually you have to go through some sort of a court procedure before the bank will honor it. And that's really important because a lot of attorneys think, oh, an affidavit of heirship is what you always do when somebody passes away and there's only the house. But it's important to note a lot of banks won't honor that. Some will, there's one or two that will, but most banks will kick up a fuss where most mortgage companies will accept it. And I say most because in each category, there are people that will and people that won't. Usually with mortgage companies, if they want you to do a probate and get a court order, and they'll run you through the whole gamut, and then you get down to the time and the court hasn't been able to see you yet, and the mortgage company realizes that they're going to lose because the sale's not going through, they'll usually take the affidavits at that point. But, it's just a big mess. But anyway, that's what a will is. Let's see what we got here. Oh, hitting the wrong thing. What is probate? I think I've explained that to you. It's the procedure where the court verifies the will and approves of it. Intestate probate is probating the estate without a will, and there are intestacy laws in Texas, and that means laws that say who gets what if there's no will. It's important to remember that most probate and most trust laws are sort of default. If you haven't said anything, these go into effect. So if you want everything in your estate to go by default, that's fine. But if you want to be sure of where it's going, you really need a will or a trust, one of the two. In intestacy, the court comes in and you submit an application that says who all of the heirs at law are. That means the ones that are in the actual law. There's a whole complicated way that you figure out who gets what, and it gets more complicated the further out you get. But when you go in with intestacy, you submit the application with the intestate heirs and a sort of a brief description of the property and the whole bit. And then you go into a hearing. But before that hearing, you have to give notice through a newspaper, which is about $150. The court appoints an ad litem attorney to make sure that you've named all the heirs. They don't trust you to necessarily come in and name everybody, and you may not know everybody. You have to put a $450 bond up for that, but then on average, the ad litem charges between $600 and $1,200. So that can be costly. And then added to that, let me think what else. Well, there's the filing fee, which is about, $390, I think now. They keep bumping it up. And then after all that, you have to put another notice in the paper that's about $90-100. So it can run $1,000 just in the court fees, not even in attorney's fees, if you don't have a will. And basically, when you go to an attorney and they tell you what the fee is, that doesn't include the filing fees. That's their fee. So if you're shopping around for attorneys, ask them, does that include the filing fees and court costs? Because a lot of times they'll quote you, but it doesn't, and then you get a nasty surprise later on. And I guess that's pretty much what probate is. You have a hearing after the ad litem's looked over everything. If you've got a will, you just have a hearing after you file. You don't have an ad litem in that case. And then after that, when the court approves the probate, they appoint either an executor if you have a will or an administrator if there's no will. Now, if there's no will or if there are children involved, the court can request a bond, which they do a lot of times. And almost always with children, you can count on having to post a bond unless you've waived it in the will. And that bond is usually, a percentage of the value of the estate. The total bond is the value of the estate plus a year's interest. But you go to a bonding company and they charge a small percentage of that. So, that can be very costly too if you don't have a will because you haven't waived the bond. And in a will, you can pretty much waive most probate requirements other than court costs and not court costs, court approval of the will and filing an inventory. And if you have a will, you can do what's called an affidavit in lieu, which just says, I've already done an inventory and given it to everybody who's concerned, so I'm not going to file it with you. In a regular intestate probate, you have to file an inventory on file so it goes on record. How am I doing on the 10 minutes? Okay.
We're getting kind of close. So.
Okay. A trust goes around probate. Think of a trust like a good friend that you have who always does what you say. You give your friend title to everything you own, and then when you want something done, the friend listens and does it. So basically, when you pass away, you've told that friend what you want done to it with the trust document is the friend. And so it doesn't go through probate because you've already given it all away. So it's not in your name. The main purpose of probate is to transfer legal title. When you buy a house, they do a title search and they check that from the time the subdivision was created, that there's a deed from the creator to A and from A to B and B to C and C to D and so on. Well, if one of those people's dead, they can't sign the deed. So one of the main purposes of a probate is appoint somebody who's got that power so that you can have clean title on all the property and the bonds and stocks and all that stuff. In a trust, you've already given away title, so it avoids probate. And the trustee just, does whatever it says in the trust. There's the only other way to avoid it, you can avoid it with real property by doing what's called a transfer on death deed. And that's a deed that tells people who you want to have the property. It doesn't go into effect until you pass away, but it has to be filed at least a year before you die. A lot of places will honor it even closer to your death time, but it's best if you do it at least a year before you die. You don't have any questions raised that way. But that's what a trust is, and that's what a transfer on death deed is. Let's kind of skip through here. Living trust is what tells people how much a living trust is. You want all the tubes off if you're declared terminal. Is what a living will is. A living trust, on the other hand, is simply a trust that is that you're the trustee of and that you can cancel at any time. There's two types of trust, revocable and irrevocable. Revocable, you can cancel at any time and it's still treated as if you own it for tax purposes. Irrevocable is treated as if it's a totally separate entity for tax purposes. And you can't control it and still have it be irrevocable. Yes, an estate always has to be probated. Yeah, that was a living trust. Okay. So a living trust is just a revocable trust. That's all it really means. It means it's one you can take back. That's what they usually use for planning, unless you've got some real tax problems. Must an estate always be probated? Usually yes, except when there's only real estate, and then you can do, as I said, a affidavit of heirship if you're just going to sell it. A living will is one where they take off all the tubes if you're terminal. Living trust is what you use to manage an estate and still keep it in your tax returns and things. A living will is what you is telling people that you want everything taken off except something to make you comfortable with your terminal. Let's see here. Basic estate planning documents, that's them. A will, a financial durable power of attorney. That's a statutory durable power of attorney is what that is. That's just, and there's, you can choose on the financial durable power of attorney. It can be what they call springing, which means it doesn't go into effect until a doctor has written a letter that states that they believe that you're not capable of handling your business affairs. Or it can be just a regular non-springing one, which means it goes into effect the minute you sign it. A medical power of attorney is not the living will. That's what tells people who you want to make medical decisions for you if you're unconscious and unable to make them yourself. The directive to physician is the living will. When they talk about a living will, what they're talking about is a directive to physician. That tells the people that if you've declared me, if the doctor has declared me terminal and you don't think there's anything more you can do for me, just remove everything except what's necessary to make me comfortable. And the designation of guardian in case of later need, those are put in because everybody has at least one greedy relative in the family. If you've already stated who you want to be guardian, it keeps them from being able to swoop in and try to get a guardianship. It just discourages people from trying. Doesn't mean you won't get a guardianship if you need one, but at least the person you don't trust won't be your guardian. And a HIPAA, that's what you sign when you go into the doctor's office. It just says the doctor can talk to your relatives, is pretty much what it says. And it says that all the medical people can exchange information. And I always include one of those because if you need these others, a lot of times you aren't conscious to sign a HIPAA at the time, so everybody needs one sitting in their back pocket. And so that's all of the basic planning documents.
Okay, Lee, we'll have to wrap it up here.
Okay, well, that's pretty much it.
Okay. Anybody have a question? Take time for maybe one question. If anybody's got one, feel free to unmute and speak up.
Oh, and that's the end in Wingdings. Go ahead.
Anybody?
Hey, Lee, can you explain the process of transfer on death versus going to probate if there are
Well,
certain
transfer
properties?
of debt only works on real estate.
And what about beneficiaries on financial accounts, bank accounts, things
No.
of that nature?
No. You want to do a pay. You want to name a pay on death beneficiary on those. You still need a will though, because a lot of times banks lose that information and then they won't do anything if they can't find it.
Very good. Thank you, Lee.